motu ia. Ko te papa e takoto mai nei, ko rangi au fia, rangi au fia. Hoki mai ngā uni mahiu, nā hi tere tere. Hoki mai ki ngā mahi tūpuna, ngā mahi hauhake. Tiri tiri a, haura kau kia tu ai tō whare. He tohu tēnei o te ora, tiri tiri a, rui rui a.
Tēnā tātou katoa. We will just kick off with a karakia and then we'll get stuck in. Tui ia he ariki he tauira. He ariki he tauira ka pikitia te paipai tuatai, ka pikitia te paipai tuarua. Tui ia i runga, tui ia i raro. Ka rongo te pō, ka rongo te ao. I te kōrero, i te wānanga, pūā takataka, pūā whiowhio. Te marama hunuku, te marama hurangi, te marama katakoto i te hau o marangai. Uhi, wero, tau mai te mauri. Haumi e, hui e, tai ki e. Aotira tēnā tātou katoa. Ngā mihi nui kia koutou mō tō koutou tainga mai tēnei pō. Kōanaru tūnoho rao tōku nei ingoa, he uri tēnei no raukawa kiuta, raukawa kitai. Ko mātou te Tiriti Action Group pōneke he rōpū hapori e tautoko ana i ngā mahi mo te rangatiratanga, te kotahitanga, me te tika i roto i te whanganui ātara me te awakairangi. We stand under the korowai of mana whenua, the Tiriti Action Group pōneke. With te kotahitanga o Taranaki whānui ki tūpoko o tika. And we're committed to realising the promise of te tiriti o Waitangi in this rohe. Our kaupapa is rooted in peaceful resistance, guided by te kahu o te raukura, and determined to organise our communities toward a future where te tiriti is upheld in action, not just words. We were born following the waipapa hui that was called by the OGs last year that led to the declaration of a nationwide hikoi, and our pilot project was actually organising the pōneke leg of the hikoi to welcome the motu back in November. But we're here tonight because the Regulatory Standards Bill is part of a wider assault on te tiriti o Waitangi. And just like the Treaty Principles Bill, it threatens to rewrite the rules in ways that strip mana from Māori and undermine the relationship guaranteed by te tiriti. These pieces of legislation are not isolated, they're coordinated and calculated. But we've faced this before. Just last year, thousands of us came together on Kotahitanga for the Toitu Te Tiriti Hikoi, a powerful stand against attacks on our founding covenant. We showed the country what it means to move in unity, to protect what matters most. And now we need to do it all over again, as hoha as it is. If you're not already connected with the Tiriti Action Group pōneke, please, we encourage you to follow our mahi. We'll make sure we put some of the links to our pages in the chat. This fight doesn't stop here. There's more work coming in as we prepare to resist the attacks on the Māori wards in the lead up to the local government elections later on this year, and continue pushing for a future grounded in rangatiratanga and justice. Toitu te tiriti, so let's get into it. Before I introduce our special guest tonight, please introduce yourselves in the chat. Throughout Melanie's kōrero, feel free to also post pārtai in the chat and she can answer them at the end of her presentation. So without further ado, our special guest tonight is Melanie Nelson. She'll help us better understand the implications of this bill and how it fits into the wider legislative agenda. So we're honoured to welcome her to our webinar this evening. Melanie is a bilingual and cross-cultural consultant, a licensed Te Reo Māori translator, and a strategic advisor who supports organisations and communities to navigate the complexities of te tiriti o Waitangi and bicultural relationships in Aotearoa. Melanie has been a leading voice in unpacking the implications of the Regulatory Standards Bill and its connections to the Treaty Principles Bill as well. Her analysis highlights how these legislative changes could profoundly alter the practical application of Te Tiriti, potentially undermining Māori rights and the foundational relationship between Māori and the Crown. Nō reira, kei a koe Melanie, nau mai, haere mai ki Wanganui a tātou.
Tēnā rā koe anaru, o te rā tēnā rā koutou e whakarongo mai nā i o koutou kāinga i tēnei pō. Ki ngā mana whenua o tēnā rohe, o te whanganui ātara, tēnei rā te mihi ki a koutou, ki o koutou maunga whakahi, ki ngā wai kōriporipo tēnā rā koutou katoa. He uri hau no Ngāti Pākehā, e tipu ake au i te tauihu o te waka, e motueka, i te rohe o Ngāti Rārua me te ati awa. Ko hoki au ki te waipōnamu noho ai i tēnei wā. Nō reira, e mihi ana ki a koutou katoa. No te rā, ki a koutou o Tiriti Action Group pōneke, tēnei te mihi i a koutou. Mahi katoa hei hāpai ake i te tiriti mō tātou o Aotearoa. Tēnā koutou. So I'm Melanie Nelson. I'm Pākehā, originally from the South Island and back living down on the South Island these days too. And I grew up in Motueka, and that's where I started learning te reo Māori at high school, and that's taken me on this convoluted journey to where I am at the moment, working in the cross-cultural space and suddenly quite active in the political space around those and much broader issues too, particularly environmental and conservation issues and te reo. So it's a real pleasure to be here with you tonight, and really appreciate what I've seen of the work that Tiriti Action Group Pōneke is doing, and these events to weave in people from around the country and across different kaupapa, so important at this time. So I'll get straight into it, because the Regulatory Standards Bill is a complex piece of business. I've got a slideshow to walk us through its key components and various detail around those. And as Anaru mentioned at the end, there'll be time for questions as well. So I'll leave plenty of time for that so that we can unpack some of what you guys who are listening most want to know. So I'll just share my slideshow. Oh, no, not that way. Cool. Is that coming through all right? Yeah. Ka pai. So you've probably all been hearing recently about the Regulatory Standards Bill, because it's really just taken off in the nation's awareness, and there seems to be a big wave of understanding that it's incredibly important and that it actually affects everything in Aotearoa. It's been termed by Jonathan Boston the Everything Bill, which I think is a really good name for it, because although we talk about its connections to the Treaty Principles Bill and Te Tiriti, and it absolutely does do much of what the Treaty Principles Bill set out to do, it also does affect everything else and everybody. So we don't want to misperceive it as just a treaty issue, not in any way using the just to diminish the significance of the treaty issue that it is. All right, can you see the slides all right still? Do you see? Yeah, cool. Okay, so it sounds really, really boring. So awesome that you've showed up here on a Thursday night to learn about it. And it's really great you have, because it's one of the most important bills we have seen. ACT's been trying to pass this bill for nearly 20 years. And this is their fourth attempt. So this time it's agreed to be passed under the ACT National Coalition Agreement, not just taken to select committee like the Treaty Principles Bill was. But important to know that the bill's contents in detail are not included in the coalition agreement. Just says to pass this act to to support good lawmaking, etc., as soon as practicable. So in theory, that means that all of the contents and focus of it need to be agreed by all the coalition parties, so New Zealand First and National. And we've just recently heard both National and New Zealand First say that they'd like to see some amendments to it through the select committee process. So that's promising, but we need as many submissions as we can get, and as many well thought out submissions as well, for those who have time and capacity to put in more than a one-liner, but even a one-liner is going to really benefit the overall numbers. And this is both to show National and New Zealand First that it's not wanted and it should never find a place in our laws, but also so that if it does pass, that there is significant, I guess, oomph behind the opposition to it, so that a future government will find it easier to repeal, and there'll be more obvious public backing for that move if it comes to that. So what is it? So it's been described as meta-regulation, and that means that it's kind of like umbrella legislation that sits over top all of our other laws. And legislation includes both primary legislation, so our laws, and also secondary legislation, which we often refer to more as regulations. And so the Regulatory Standards Bill says that most of our laws should align with its principles. And the principles are mainly libertarian ideals and redefinitions of some familiar concepts too. So you'll see things in there like consultation and the rule of law. And we'll get to these a bit later, but they're not quite the normal definitions. They've been adjusted to fit Act's ideology more. And what this law does is that, this proposed law, let's try and not let it become a law, it embeds legal frameworks that prioritize individual and property rights over pretty much everything else. They constrain regulatory powers, these frameworks, and reduce the government's ability to implement environmental protections, social safeguards, and tiriti-based initiatives. For example, I've just been doing a series of interviews for my podcast Coherent this week, and interviewing a range of different experts on the implications and possible flow-on effects in their fields. And it's absolutely mind-blowing the flow-on effects that this bill could have if it's passed. So it has a long history, as I mentioned. Jane Kelsey's termed it the final puzzle piece from the 1980s neoliberal reforms. And it was actually first dreamed up by the Business Roundtable, who are now known as the New Zealand Initiative, in their 1990s advocacy for an economic constitution following the 1980s reforms. And in 2001, they published a report called Constraining Government Regulation. It was authored by Bryce Wilkinson, who's actually still one of the key voices that we hear advocating for this bill. And that report included a draft regulatory responsibility bill. So that was actually the first version of this bill, and Act adopted that, and it was drawn from the ballot in 2006 and introduced. And we'll touch into the Treaty Principles Bill a few times through this presentation, but not many people know that was actually the same year that Act first introduced its initial version of the Treaty Principles Bill, which also failed. So the regulatory bill was blocked by Labour that time, and in 2009 it was revived through a regulatory responsibility task force, which was set up by Rodney Hyde and Bill English. And then in 2011 was reintroduced as the Regulatory Standards Bill. Didn't pass, was opposed by the Legislative Advisory Committee, Treasury, all sorts of others. And there was a lot of criticism of its focus on property rights and the fact that it was sort of setting up this corporate Bill of Rights, which seemed to conflict or sit alongside in an awkward way the actual New Zealand Bill of Rights. So fast forward to 2021, and it was reintroduced by David Seymour, and again failed to pass. So David Seymour has been saying recently that it's fine that they're shortening the select committee period to 4 weeks for written submissions and 4 months for the full committee, rather than the normal 6, because it's the most consulted on bill in our history. And that may be true, but the other side of that is that it's the most rejected bill in our history, or one of. I think there's one other bill that didn't pass until its 5th reading. And that was in like 1896 or something like that. So Emeritus Professor Jane Kelsey has said that if the Business Roundtable and ACT had had their way, these directives and guidelines would have become a legal straitjacket. And indeed, that's what they would do if this bill does pass. So where are we now? I'm sure some of you submitted in the consultation round on this bill on your Christmas break. It wasn't very well publicised, and it was pretty close to Christmas when I started writing and interviewing about it. But despite that, 23,000 people nearly submitted, and only 0.33 were in support. That's 76 total submissions. So not that many. And David Seymour's recently claimed that 99.5% or something of them were bots. So I guess he means all but those 76 were bots. But he doesn't have any evidence for that. And of course, there would have been a big complaint and investigation if there actually was fact behind that. So I think maybe by bots he means brilliant original thinkers or something like that, of which there were probably 22,500 of those submitting on it. So it's passed its first reading because they pushed it through anyway without paying much attention to the submissions. And Seymour said that there really were no good or useful ideas in the submissions. Currently, it's at Select Committee, and submissions close on the 23rd of June at 1 in the afternoon, so not the midnight deadline that we had previously. So what's in it? It's got 4 key aspects that I'm going to cover tonight. So one of its core components is this set of principles that I mentioned, and we're going to get into those in a minute. And as I mentioned, they're really a libertarian set of principles, the ACT Party's ideology encapsulated down into a few sentences. And it provides that both new and existing legislation and regulation should be assessed against these principles for consistency with them. And that, with a few exceptions, all the rest of our legislation and regulation should either be brought into compliance with these principles over time, or if it's not, that the government has to publicly justify why not. And these principles are being described as principles of responsible regulation. And so part of what we're seeing here is an attempt to define other things, like, for example, collective interests, the environment, te tiriti, the public good, equity, as being outside of the realm of responsible regulation. So if you were making laws that uplifted those things or even just balanced them with other libertarian values, you'd be seen as doing irresponsible regulation and legislation. We also have a regulatory standards board, which is created by the bill. And that board has been described as a bit of a Waitangi tribunal for libertarians. It has a fairly similar jurisdiction in some ways, and there's some real mirroring of the tribunal, both with being able to investigate these principles, though a set which are plucked out of ACT's manifesto rather than out of our founding document, and being able to assess legislation and for consistency. So there's some really similar terminology. And we'll come back to the board in a bit more detail later. And it also gives the Ministry for Regulation responsibility to monitor how well the overall regulatory system is working and gives them quite significant information gathering powers to do that. So able to request information from all the other government agencies, the Reserve Bank, councils, and third-party providers of government services. And if they fail to provide that information, that would be a contempt of court. So what are the principles? They're categorized under these categories. The rule of law, the protection of individual liberties, protection of private property rights, imposition, I think I might have put private in there, imposition of taxes and charges, role of the courts, and good lawmaking. So we'll go into a few of these in a bit more detail, but first I'll just give you a bit of a summary of them. So some of the principles are about liberty and autonomy, and the next few slides are summaries of the principles, but I'd encourage you to go look at the legislation to see the full detail. So it's important to know that whenever we see the term individuals or persons, that includes corporations. And this is one of the key concerns and risks with this bill, is that it could appear to be giving you and me more rights and liberties, but actually it's really not about the liberties and rights of ordinary people. It's about corporate rights and the rights of the wealthy. So the essence here is that individuals and corporations should be free to act unless there's a clear justification to restrict them. The strong focus on property rights, that regulation should not take or impair property rights without consent or compensation. We'll come back to the compensation. Just briefly on the compensation here, if regulation restricts property rights, and think broadly here, property is not defined, and it's going to include things like intellectual property, lost profits or business opportunities, brands, branding, labeling. So very, very broad. Then the affected parties may be entitled to compensation. And the cost of that compensation is meant to fall to whoever is deemed to benefit. So that will often be a bit difficult to quantify. So it is quite likely to often fall to the ratepayer and the taxpayer. But there's situations where maybe if it was a regulation to restrict damage to a wāhi tapu, that it may be the iwi who are deemed to benefit, for example. There's a real strong leaning towards minimal intervention and framing regulation as burdensome rather than something which looks after us and protects our well-being and our environment and our safety. So the bill believes that regulation should impose the least possible restriction necessary to achieve its objective. And cost efficiency is a big driver here too. The benefits of regulation should outweigh its costs based on quantifiable analysis. And of course, there are so many things which are not readily quantifiable in financial terms in that way. Like, what value do you place on a worker's life with health and safety regulations, or a clean river to swim in? These things are very, very hard to quantify. What about the prevention of climate change? And in what time frame are we thinking? Is it cost benefit and cost efficiency in the next 2 years or in the next 200 years? Also in here is equality before the law, which probably rings a few bells for anyone who tuned into the Treaty Principles Bill, that laws should treat all persons identically under the law with few exceptions. Remember, I've paraphrased these principles here, so go check out the full wording, but this is the essential meanings. And of course, the Treaty Principles Bill highlighted, the narrative around that highlighted that this would be detrimental to Māori because, of course, there's a need for targeted treatment based on historical injustice and disparities. But it's also just as relevant to any other marginalised group or minority. So could be disabled communities aren't meant to have, the special treatment that's needed for them to be able to participate, or the anti-equity legislation is a good example of no special treatment for women, for example. And lastly, I think transparency and accountability are core here. And I've put, and pressure, because transparency and accountability, of course, are really important, but what is meant by those by David Seymour and by this bill? So this is about lawmakers needing to justify regulation through reasoned analysis and public reporting. And there are various mechanisms layered into the bill that will then utilise those processes of transparency to apply significant pressure to governments to not legislate in the public interest and to not legislate or regulate to impact corporate profits and freedoms to do as they wish. So although the bill is, I guess, voluntary, it's not binding on the government to follow these principles or to legislate in line with them. There's a huge amount of soft power at play here and a huge amount of pressure through various avenues that the bill creates to tip the balance away from the government taking the risk of legislating in the public interest. And so all of these aspects of it are significantly concerning to anyone who cares about society as a whole. Libertarians, of course, don't believe in society. Anyone who cares about the environment, anyone who cares about te tiriti, equity, human rights. The Bill of Rights is not listed in these set of principles for responsible lawmaking. So, look at a little bit more detail at the liberties principle. That legislation should not unduly diminish a person's liberty, think corporation as well, personal security, freedom of choice or action, or rights to own, use, and dispose of property, except as is necessary to provide for or protect any such liberty, freedom, or right of another person or corporation. So this is really important, this one, and this wording. As I mentioned, this is including corporations. And what this basically means is that the only reason that, if you're in consistency with these principles, the only reason you can restrain what a person or corporation can do, including with any of their property, business, mining rights, whatever it is, you can't restrain what they do for the environment. You can't restrain what they do for the public good. You can't restrain what they do because of te tiriti. You can only do it in a responsible regulation way if it's protecting a similar individual right or property right of another individual person or corporation. So what we currently see, of course, is that our parliament balances a huge range of values, which includes individual liberties and property rights, but it also includes the environment and te tiriti and equity and the public good and several other important things, the Bill of Rights. So this is a significant shift. I'll just play a little clip from Professor Jonathan Boston. I'd recommend listening to his full interview on my podcast Coherent if you're interested.
Another consideration would be measures to protect the public welfare or enhance the public welfare. So, for example, measures to protect public health or to do things that generate public benefits, such as having a conservation state, national parks, and so on. These sorts of things can infringe on people's rights and liberties. They can infringe on property rights and so on, but they're not justified in our kind of system on the basis of minimizing harm to another individual or their property rights. They're justified on the basis that these things are good for society as a whole. But of course, the problem with a neoliberal model of things is that kind of societies don't exist. and people are not interested from that perspective in enhancing the common good or the well-being of the society as a whole, because, well, society is irrelevant. So just focusing on this principle, this liberties principle, just highlights the very, very restrictive nature of the proposed legislation. Much the same applies to the so-called takings provision that's in this proposal, and likewise the proposals in relation to taxes, fees, and levies. The way the principles are formulated under those areas would impose very significant restrictions on what governments can do. Another consideration.
He sums it up very clearly, and every time I listen to it, I feel just as shocked and concerned as the first time he said it. So we'll have a look now at another one of the principles, and this is around the taking of property, which is referred to as regulatory takings, and that means impacts on the value of property through regulation or legislation. So this principle is that legislation should not take or impair, without the consent of the owner, property, unless there is good justification for that, fair compensation for the taking to the owner, and that compensation is provided to the extent practicable by or on behalf of those who obtain the benefit of the taking or impairment. So, in simple terms, regulatory takings means that if government makes legislation or regulation that impacts on property rights, which of course, as I mentioned, includes intellectual property, say mining rights, a leasehold, for example, then property owners, including corporations, should expect to get compensation. So the bill doesn't directly create the compensation opportunity, but it says that legislation should include that if there is going to be limitations placed that affect the value of the property. So there's potentially quite significant scope for judicial review of processes that fail to meet that under the RSB. Here's Emeritus Professor Jane Kelsey talking about the takings clause.
In this bill, there is also something called a regulatory takings provision. This has never existed in New Zealand law. And what it basically is a protection of the private property rights of companies, especially if governments are to regulate in ways that impact negatively on their investment. Now, this government is going hell for leather to remove all restrictions in the way of, think of the fast track bill, of many quite harmful activities. And a future government may want to re-regulate those. That would be a regulatory takings that the companies that don't like it could take to the domestic courts and seek compensation. Now, what we don't know is there's nothing in there that gives us any detail on this, including what kind of compensation they could get, what kind of rules have to apply, whether there could be anything about, yes, but your activity is harmful and therefore there's a justification. We don't know any of that. It's a US protection of property rights rule where there is none of that, none of those protections. It's also very similar to what we have in the free trade agreements of what's known as investor-state dispute settlement, where a foreign investor can bring a case in an international tribunal against a government for adopting regulations or decisions that impact negatively on their investment. And what they claim there is not just loss of what they've invested to date, but the whole lifespan of the future profits that they were anticipating with compound interest for maybe a 30-year lifespan. That is so bad that successive governments, the Labour-led government of Ardern and the current government, have said they will not accept that investor-state dispute process anymore in future agreements. But here ACT is talking about something similar to that in the Regulatory Standards Bill, and no one seems to be taking any notice. In this
So Jane Kelsey has been tracking this bill since before it was written, I think. One of our foremost commentators on the neoliberal reforms in the 1980s and continued efforts since then. And you can catch the full interview on Coherent too if you want to listen to more about that side of things. So here's some examples of what might be considered a regulatory taking. So first one I've got here is breaking up of monopolies and oligopolies like supermarkets or electricity companies, or capping markups at supermarkets or in electricity prices could be considered to be taking away value of the business that gets broken up, and they could expect to be claiming regulatory takings. And I interviewed an economist on this a couple of days ago, and we'll get that interview up in the next few days. But he said that, you know, you could have the ridiculous situation where you break up a supermarket so that prices get lower, or you cap the markups they can do, but then they're expecting compensation, and those who benefit from the lower prices are consumers, and so consumers should be giving compensation to the supermarkets, so maybe, or to the electricity companies, so maybe you have to pay a fee to government who then pays the compensation, so you end up paying just as much out of pocket as you were. So that was an interesting example to explore a bit. Labelling is definitely something which would be subject to this, and there was a significant case in Australia when they were required to have plainclothes labelling on their cigarette packets, and the company claimed regulatory takings in the courts, and so was able to keep trading as they had been for quite a number of years while that court case proceeded. Limiting things, so the right to pollute could also be a property right, so limiting the right to pollution could be seen as a regulatory taking because it would add costs to the business. Protecting waihi tapu or biodiversity on private land or mining areas, for example, and we've seen this one actually come up in the proposed replacements for the RMA. There's regulatory takings going to be in there, and any council that goes beyond what the national standards are would be expected to be compensating, say, landowners for the lost value of their reduction in property value because of the protection on part of the land, for example. Rezoning could be considered a regulatory taking to prevent commercial development in certain areas, could impair the property value of those landowners. Or a sugar tax, for example, to improve health outcomes could be considered that too. So there are some of the examples, and they're probably fairly endless if you start your mind thinking about in the area you work in or are interested in, what might regulatory takings be, what are the corporate interests in that space, and if they were restricted and what they could do for the public good or environmental reasons, what compensation might be payable. So other key aspects of the RSB, it's likely to lead to extreme deregulation because there's a preference for minimal interference. It's hostile to government discretion, which when you think about it, so much of government actions and decisions are about discretion, about relating to people in culturally appropriate ways for them, about in the context, how do you balance these different interests and views? The application of the treaty principles through legislation is, of course, very discretionary and requires judgment and understanding the context, both of what the principles are that are relevant there and how they would apply to that context at the time. As I mentioned before, it also gives these powers to the Ministry for Regulation and the Minister for Regulation, who's David Seymour. And he also gets a role in interpreting these principles, how they're to be interpreted and applied. And also this Regulatory Standards Board to consider new and existing regulation and legislation. So when it was consulted on at Christmas, some of you may remember their role was just around existing regulation, but it's now been extended to new legislation too. So the board is this recourse mechanism, and any legislation or regulation which is inconsistent with one or more of the principles can be investigated and inquired into by the board. So the board members are going to be appointed by and accountable to David Seymour, the Minister for Regulation. And he's said that they will be regulatory economists. And investigations that the board does, anyone can take a complaint to them about legislation or regulation being inconsistent. The minister can also initiate a review, and the board can kick off its own reviews too. It can only recommend, so this is important, it can't strike down legislation or regulation. It evaluates whether legislation lines up with this set of libertarian principles, and they'll issue recommendations. And some of these examples make you think twice when you look at what sorts of complaints might they be receiving, because it's a little bit bamboozling when you start thinking about it. So it could be complaints about laws that recognise collective Māori rights, or te tiriti, for example, because they could be considered inconsistent with individualistic rights and the notion of formal equality before the law. Could be complaints about environmental protections because they are considered inconsistent with unrestrained property rights. Or it could be complaints about social safeguards because they're inconsistent with formal equality before the law, or the taxes and levies principles, for example. So this board, although it only has recommendatory powers, it's likely to carry really significant political weight and will have a lot of influence on ministers and the public as well. Ministers will need to justify their actions publicly if they are legislating or regulating inconsistently with any of those principles. So anytime they uphold te tiriti, they'll have to be defending in public why they're not following the principles of responsible legislation, for example. So likewise, if they're legislating in the interests of the public good instead of corporate interests. So although Parliament can override the principles and retains its sovereignty, there's just going to be so many hurdles: political pressure, procedural, time, financial, risk of judicial review, risk of threats of compensation being demanded, that all combined are really likely to deter future governments from stepping too far away from the bounds that these principles would set in place. And it's been described as a chilling effect. So quite likely many policies would never get beyond the office that they're, thought up in, because the hurdles to jump through, and the time and the pushbacks from the Ministry for Regulation, the Minister, the board, the public, public justification, are likely to just be daunting and mean that the legislators just simply do not progress many of those things which they would otherwise progress. So lastly, we'll have a bit of a detailed look at the effects on te tiriti o Waitangi. So as you are probably aware by now, there is no principle around te tiriti or the treaty principles and within this definition of good lawmaking. And we've recently had a really powerful Waitangi tribunal claim by Toitu te tiriti, and the lawyer Tania Waikato led that claim, and the tribunal found that the Crown breached the principles of te tiriti in its process by not consulting directly with iwi and Māori, and also that if this bill was to pass in the form proposed, it would be a massive constitutional breach and breach of te tiriti. I've also got an interview with Carwyn Jones going to be posted soon, who was one of the expert witnesses. So check that one out if you're interested in this side of things. So another aspect of this is that the individualistic property-focused rights in the RSB really seem to butt up against and conflict with the collective rights guaranteed to hapu, rangatira, and Māori under te tiriti o Waitangi. So there's going to be a fundamental inconsistency in legislation and at that constitutional level if this passes. Treaty settlement legislation is excluded from having to comply with the RSB, and so is the MACA Act. This is a bit of a double-edged sword. It means that, of course, those settlements can continue to be full and final, but it also means, and the various measures included in those can continue, even though they're differential treatment. But it also does mean that, for example, the foreshore and seabed issues couldn't probably be revisited under the RSB with claims for fair compensation as the RSB requires. So it leaves Māori past and future settlements in the realms of that 1 to 2% of what was lost rather than fair compensation. So none of this stuff is simple and clear cut as to what the best way forward would be if it is to proceed. So the best way forward is for it not to go any further, if you ask me. And other treaty rights like affirmative action or equity measures are likely to be inconsistent with the RSB principles as well. And of course, when the settlements were made, and they're still being made, they commit to a new relationship based in te tiriti. So with te tiriti being removed or displaced from our lawmaking processes, and it's currently a core part of it, te tiriti and the principles, it really does raise questions about those commitments made in those treaty settlements. And likewise, the settlements don't encode all Māori rights and interests, and this was made clear at the tribunal hearing as well. They are historic settlements for what was lost and past injustice, but it doesn't absolve the Crown of its responsibility to take responsibility for Māori and for equity and progressing into the future. So a lot of the environmental provisions, for example, that could be threatened or repealed under the RSB when it comes to review those laws, were assumed by many iwi to be long-term in place. And so those provisions weren't perhaps codified within their settlements because they existed in the wider legal framework, but there wouldn't have been the expectation that the whole legal framework might be rewritten from a completely different ideological perspective. So the connection with the Treaty Principles Bill, the RSB shapes how legislation and regulation are developed, and determines the foundational values that they are based on, whereas the Treaty Principles Bill is really about how legislation is interpreted. But given the similarity of the principles proposed in both bills, and the ideological meanings under the principles, if you interpret legislation through these principles, or if you create legislation based on these principles, you're actually achieving many of the same things, whichever method it is you take. And if you take both, then that's a full capture. So the relationship with this Treaty Principles Bill, although they're different, they could really significantly intersect, and the principles, as I said, are very similar in both. Most people weren't aware that specific libertarian interpretations for the terms in the TPB around the rule of law, fundamental human rights, discrimination, equality before the law, and free and democratic society, they're things which sound kind of normal and fine, but the libertarian meanings, they're all about individualism, property rights, and minimal government intervention. So I've got some articles on my Substack back in, I think it was December, if you're interested in delving into what those meanings are that are so different from our common usage meanings. So finally, I know that's all quite a lot and probably quite scary and daunting for many people, but it is really important that everyone submits on this and go talk to other people about it, develop your own understanding, look at how it affects the areas you care about. We've just put out a new tool a couple of days ago, which has questions for 60 or 70 different sectors or areas of public life, reflective questions to consider how it might play out in the area you work in or are interested in. So go check that out. There's some really good submission tools online as well. Network with other organisations, lobby MPs, and importantly, this is not just a left-right issue. So talk to National and New Zealand First MPs as well. This is a everyone and everything issue. And yeah, finally, make sure you submit to the select committee. And yeah, here's some links with various resources to my writing on this coherent podcast, heaps of episodes coming out soon. There's a couple there already, but there'll be more very soon. There's a link tree here with heaps of historic and current resources about the RSB. And of course, people have been analysing this for decades now. There's a link to our sector-specific tool. This is to our submission guide and explainer if you don't want to get too complex but want to personalise your submission. And yeah, that is the end of the presentation. So I'll hand back to Anaru and team to take it from here. Kia ora.
Kia ora, Melanie. I just wondered now, there's not as many pātai in the chat as I had expected. So I just wondered whether there were some pātai from our viewers, if you'd like to post them up in the chat. And we'll see how we get on. I suppose one pātai I've got for you, Melanie, is if we could collectively shift Aotearoa towards a truly Te Tiriti-based future, what do you think it would look like? And how do you keep that vision alive when things feel so overwhelming like they are at the moment?
Yeah, good question. Someone said to me the other day, because you'll see there I've got another podcast which is called Weaving Our Worlds, and that's about building understanding and, you know, imagining that future and looking at the cool things people are doing now towards that kind of a future. So yeah, someone said to me, don't you just want to go back to just doing Weaving Our Worlds? And I was like, yeah, I do. I really do. So yeah, I think, yeah, although this is dark times and dark proposals, it offers a real opportunity for us to not just react and respond, but we need to do that and condemn that direction, but we also need to really be envisaging the future that we do want, and sharing what that looks like and making it seem tangible and real and hopeful for people. And what are our relationships like? How do we deepen our understanding of different perspectives to get to that place without having to discard other people's perspectives? What's the environment like we want to live in? So I think that's incredibly important to be doing that at the same time and not letting all our energy be drained by the attacks on that possible future.
We've just had another partai come in from Sharon. Can the whole thing, probably related to the bill here, can it be overturned by a new government? How easy can that be done if it does,
it should
get
be
passed?
it should be able to be. There was concern earlier that because there was a public binding referendum in the 2021 bill, there was concern that it could be entrenched, but that's not part of this bill. So a simple majority in government shouldn't entrench a law, so it should be able to be overturned by a simple majority when the government changes. But submissions are going to be really important for that to be, to have a clear public mandate. They're going to need to be able to fall back on, going, look, the public, 80% of the public or 90% of the public didn't want this and you did it anyway, so we're listening to the people. But in saying that, I also do think we need to pressure the coalition partners now to make this not as bad, or to slow it down, or to block it, because it could do a huge amount of damage in the next year after it passes, while we still have this government, or if they get another term. So, whether a new government would unwind everything it had done seems fairly unlikely. Like, you can't just do a factory reset of our laws to 2023 or whatever it was. So there's a lot that could happen in the meantime, and a lot of shifts in people's minds and their culture. And we've already seen Seymour achieve quite a bit, I think, in that way through the Treaty Principles Bill process. So this is another whole layer of it. And once that board's in place and Seymour's got the superpowers of being a bit of the upper house law lord, there'll be much, much stronger public influence of our minds towards it. So it gets harder and harder to shake too.
Chrissy Williams asks, what kind of amendments are the National Party or New Zealand First likely to support to make their support for the RSB more palatable?
They haven't said, we haven't heard any of the detail yet. So I think I've seen New Zealand First a few times now say that they'll be paying attention to what's said at Select Committee. I imagine they have their own ideas, and it's kind of interesting that they were founded on opposition to the 80s neoliberal reforms and the corporate power and overseas control sort of thing. So this seems very counter to really their essential sort of founding values. So it's going to be really interesting to see where they go with it. And I don't know just what they're thinking, but I'd like to know. And National, I think there is quite a component of National that's quite libertarian at the moment, but there's also the more traditional conservatives there, and who aren't libertarians and probably aren't at all stoked about this bill. So finding those MPs and, finding out what they think, telling them what you think. I think all of those are really important avenues to be pursuing.
Dale asks, can this bill restrict future governments to sanction the likes of Israel or retrospective sanctions on Russia?
I have no idea, but that'd be a really good question to explore. And I think there's some questions in our resource around international stuff, but I don't know if there's quite one around that. But it's a really good question. I don't know the answer, but there certainly are big questions around, what if international obligations say that we should be doing something, but we have to go through all these convoluted processes in our system to actually fulfill those, or it doesn't include international obligations, and even like say UNDRIP or the Paris Accord are not, they're not part of responsible lawmaking. So there's a huge gap there, and some people, really great if people can do some analysis on that if it's their area of interest and put that to the select committee.
Cool. With probably one or two questions to go here. One from Linda: would incorporated societies need to become corporations in order to protect their interests?
I don't know, but that'll be a good one for you to look into.
Yeah.
Yeah, I'm not quite sure what how they fall under the definition of individuals or persons, but yeah, checking out the Interpretation Act and a couple of the other acts that explain that stuff would be a good starting point.
Lawrence asks what the likelihood is of the vote on the RSB being a conscience vote.
I'd say it's probably pretty low because it's in the coalition agreement to pass it, so it'll probably be a party vote. But I think what's most important there is that the select committee is clearly aware of the issues and what people think, and that goes back to cabinet, and then it's the conversations behind the closed doors in the cabinet that will have the most bearing, because if they can't agree, if National and New Zealand First want amendments that are critical to them that would make this an unpalatable bill to act, like that will be interesting to see what happens there. But we probably won't get to see much of that.
Okay, before we wrap up, Marie was just asking what the likelihood is of another big nationwide hikoi on this matter, given how powerful the hikoi for the Treaty Principles Bill was. Time will tell, I think. Whanau, time will tell. So in the meantime, please put your submissions in before the 23rd of June. Otherwise, I think we will start to wrap up. So
I'd say too on that, if you want to follow what's happening around Te Ao Māori and activations, then Tania Waikato, Toitu Te Tiriti, Tina Ngata, some of the key people to follow on social media.
Yep, good advice. Well, kia ora rā. Ngā mihi nui kia koe, Melanie. Thanks for joining us tonight and sharing all of your knowledge, wealth of knowledge with all of us. And just to conclude, this government, as we know, is pushing through legislation that divides, diminishes and disregards the promises of Te Tiriti o Waitangi. But we're not powerless. Across Aotearoa at the moment, communities are rising, not in anger, but in unity, in aroha and in fierce commitment to justice. And as I said at the start, we've stood together before, and we've got to do it again. And every activation, every submission, every conversation with whānau and friends is part of the movement to protect Te Tiriti, to uphold mana Māori, and to shape a future we can all be proud of. So this is our time to show that Aotearoa will not be silent while rights are being stripped away. We are many, we are ready, and we will not back down. So I'm calling on each of you who have joined us tonight. Don't let tonight be the end of your engagement. Let it be the beginning. Talk to your whānau, talk to your friends, talk to your colleagues. Follow and support Tiriti Action Group Poneke. Show up to rallies, submit on the bill, as I said, before the 23rd of June. Join the organising, speak truth, carry this kaupapa forward. We aren't small, we aren't powerless. We are part of a growing movement that will not back down, not now, not ever. And as Melanie said, please follow the likes of Toitu Te Tiriti, Tania Waikato, and of course, keep an eye on Melanie too. She's doing a number of these webinars up and down the country. So, ngā mihi nui kia koe, Melanie. Thank you so much for joining us. It's been a pleasure. Ngā mihi nui kia koutou katoa who have joined us tonight. Toitu Te Tiriti, toitu te mano te tangata. Let's move, let's rise, let's act, karawhiua. And with that, we will close now with karakia. Unuhia kuturu tapu nui kia wātea kia māma te ngākau, te tinana, te wairua I te ara takatu. Koiara I rongo whakairi ake ki runga kia wātea, aira kua wātea, pai mārire. Pō Māori e koutou.
Pō Māori e.